The first case that is set for oral argument is Collins versus Geiger. It's case number 29361. We have both parties present. For arguments, each of you will have 15 minutes to present your arguments. Appellant may reserve up to 5 minutes for rebuttal. We do keep track of the time on the television screen, although I'll interrupt you if you're getting close, if you're deeply into your argument, so you'll know. The parties should know that the court has read all the briefs in the matter, and we're ready to proceed if you are. So you may start.
Thank you, Your Honor. For the record, Thomas M. Wilson here on behalf of Appellant James Bresci. At this time, I would like to reserve 5 minutes of my time for rebuttal.
All right, thank you.
Thank you, Your Honor. Little by little, piece by piece, over the years that this case has been pending, the trial courts issued a number of orders and acted in such a way to deprive Mr. Bresci of his constitutional right to procedural due process. The most glaring and most recent example of this was in the court's March 19, 2019 order, in which the court at page 2 or section 2 of the order goes on to address the receiver's motion to enforce settlement agreement. However, a review of the docket will show there is no motion to enforce the settlement agreement that existed. The court, in referencing this non-existent motion that it ultimately granted, talked about and focused about a February 13, 2019 hearing. Okay, there was an evidentiary hearing at that time. For example, at the page 4 of the March 19 order, the court talks about, and I quote, "At the hearing to enforce settlement held on February 13, 2019. The court goes on again to the next page, at page 5, it says it again. At the hearing to enforce the settlement conducted on February 2019. Again, if you go back and review the court docket, there is no motion to enforce the settlement. More importantly, back in December of 2018, I believe it was December 12th, the court did issue an order and set forth a specific schedule for the February 13th hearing, evidentiary hearing. And when you look at the court's specific order, there is no mention of a motion to enforce settlement. There are 3 items set forth that were either going to be addressed or that were at least scheduled to be addressed. And when you look at that order, there's no motion to enforce the settlement agreement. Now, I don't want to be too much at looking at parsing words, though I do believe we should abide by the court's orders and by the court's words. Now, there was a motion to compel Mr. Bresci and his wife to execute releases and otherwise cooperate with the receiver. Now, that motion was never scheduled for February 13, and it's not actually a motion to enforce the settlement agreement. That's number one. But it was actually brought up rather unexpectedly during the hearing when counsel for the receiver said, "So we are here also to really lodge a complaint that Mr. Bresci has failed to cooperate." It's the transcript of page 20. Now, at that point, in response to that, counsel for Mr. Bresci, myself, we objected. And we said, wait a second, we object. And then we say, Your Honor, there's a motion, there's no motion to compel currently pending. And the court said they're going to proceed on it anyway. We objected, saying, but Your Honor, we've never received any notice on this motion to compel, and we're not prepared to go. I specifically actually said, Your Honor, if we're going, it says, I apologize. On this particular document, that is not set for, it's not scheduled for the court to hear it, for it to be addressed today, and we are not prepared to address it. That objection was moved aside, okay, and the court then did this motion on the motion to compel / under the guy's motion to enforce the settlement agreement. Now, that's March 19 of 2019, all right? This case goes back quite a bit, and the issues that are also involved here that begins with the constitutional due process violation starts with the January 15, 2018 motion of Mr. Bresci for leave to file an amended complaint in Stanton. That's 568 of the the record. Now, the trial court denied that motion, the motion to amend the complaint, the motion for leave to file the amended complaint in Stanter. Now, the problem with the court denying that, and why this moves to a constitutional or a part of a constitutional deprivation, was now, this court in Haley versus Thompson back in 2005, in the context of a settlement agreement, this court stated that it determined that it was improper for a trial court to consider matters, quote, which had not been filed with the court. Now, we have the settlement agreement that was not in the case that is below. It is in a case, a separate case called Thompson versus Summit Paint Specialists. Now, the trial court used that settlement agreement to deny the motion for leave to amend. And why does that matter? Because number one, it was never in front of the trial court. But the trial court knew about it because the trial court had been assigned or had taken over a number of cases after a certificate of assignment had been given to the trial court. And the trial court was on this case too. So what the trial court did said, well, I know what happened over here, so we're just going to pull it over here. All right? Case law is pretty specific in regard to that, which we've cited to a number of times, which is a trial court has no ability to take and transfer something from this court over to this court. During the course of the hearing, the trial court argued, oh, we can take judicial notice. Okay? At which time, I argued back, no, Your Honor, you can't take judicial notice of another case, even though you sat on it, and I cited case law in verse. Now, we've also provided that in those case law that you cannot take, the Supreme Court has said you cannot take judicial notice of another case, even if it involves the same party.
Counsel, the court said that you introduced the settlement agreement basically yourself. You introduced parts of it into the dispute.
I'm sorry,
I have a little cold too, so why don't you stand behind here because we're videotaping, okay? So I'll
my
try
apology, Ron, I just can't hear, I'm getting old.
No, that's all right, I'll try to speak up. The trial court, though, found that you were the first one to introduce the settlement agreement, not the whole agreement, but bring it into the dispute.
I'm not sure I understand.
Well, you're complaining the trial court shouldn't have looked at the settlement agreement,
Right.
shouldn't have considered it when you were the one that brought it into the forefront.
Well, we didn't, and and if you go back and look at it again, with all due respect to every judge in the world, just because they say it, don't make it so. Okay? If you go back, for example, and look at our motion for leave to amend, in Stanter, there is no mention whatsoever of the settlement agreement. Rather, we focused on a separate order, which was the order to appoint the receiver and what his duties were under that specific order. Now, we didn't bring up the settlement agreement, and I suggest to the court, if we go back and you go through that motion and you look at it, you'll never find it. Now, what happened at this motion to enforce the settlement agreement, the problem was this. I said this, and I won't argue. If the court is going to use the or the settlement agreement, it has to be, I said, it's my understanding, Judge, you filed it under seal. So if it's going to be here, I said, all I want to do as a housekeeping measure is make certain that everybody who is here in the courtroom is within the order of seal, so that it doesn't get out in the public, because that was part of the problem. Part of the problem was the agreement was confidential. So did we bring it up and make any substantive use? No. All I said was, because the court had already filed it under seal, if it's going to be brought up, then you have to make certain that, and the court did. The court went around to all the people in the room and said, were you a party? And there were two counsel for the third-party defendants who were there, and they raised their hand and said, we're not parties to it. And the court then said, all right, well, you're not allowed to talk about it. And so when we went for, but that's the only indication that Mr. Bressi brought it up either at the hearing or subsequent to or prior to in our motion. Now, it did get addressed at the hearing, absolutely. Okay, And it got addressed when counsel brought it up. Counsel for the receiver brought it up. And he brought it up in the sense that we started with, well, there's this the history of the case, and it goes back to the settlement agreement, blah, blah, blah. And we went through this whole thing about the settlement agreement. Ultimately, the court allowed counsel to admit the settlement agreement, okay, and subsequently also allowed counsel to admit into evidence a hearing transcript in the other case. And the purpose of this hearing transcript was to show the intent of the party, which, you know, as far as I can tell, not only is, we'll call it hearsay, but it's clearly a parole evidence, which is clearly not allowed. But we had, the court allowed it to come in over objection, and we objected. So,
Yeah, I'm going to interrupt you just briefly to let you know you're just under your 5 minutes. So you're into your rebuttal time by 2 seconds right now. You can continue, or...
Your Honor, I'll wait and unless the court has a question for me.
Okay. So you'll have 4 minutes and 58 seconds for rebuttal.
But who's counting?
Okay.
Thank you, Your Honor.
Good morning. You have 15 minutes.
Good morning, Your Honors. David Perdue and Larry Scanlon for the plaintiff, John Collins, receiver. Your Honors, this court should affirm the trial court's decision for these main reasons. I think it's important to go back to the beginning, how we got here, because it is very simple, it's very logical. First and foremost, Jim Bressi voluntarily and with advice of counsel entered into a settlement agreement October 31st, 2016. Jared and Thompson versus Summit Pain Specialist, 2013-05-2353. In other words, there was 46 plaintiffs alleging bad conduct against Dr. Bressi. There was a settlement. That settlement was read in open court and with advice of counsel on both sides. In exchange for that settlement, there were releases given to Bressi. There was money exchanged. But the most important thing is, why we're here today, is there was an assignment of claims. Jim Bressi, in this case, not the Jared and Thompson case, but in this case, Jim Bressi was pending claims against his business partner, Summit Pain Specialist. Those claims were pending, but over in this case, in the settlement, Jim Bressi, to settle these claims to get releases against these 46 alleged victims, I'm going to assign these claims to you. In order to do that, we're going to appoint a receiver. The receiver was appointed in both cases, Receiver Collins, or the plaintiff in this matter. So, oral agreement, that was part of the oral agreement. That's before this court, the transcript of that. Then, 2 months later, there was a written settlement agreement, again, voluntarily with advice of counsel. Both parties had not just one lawyer, they had a team of lawyers. Those agreements were comprehensive. Those agreements were, most importantly, voluntarily.
Did the receivership agreement give Bressi the right to pursue any claims on his, any individual claims?
The agreement or the order?
Well, either.
The answer is no. The agreement set forth what was being assigned. Essentially, it was his business interests in Summit Pain Specialist, or anything arising from his business interests in Summit Pain Specialist. But because you asked the question, it's important to note that Mr. Bressi's attempt to intervene in the case and assert his own claims virtually were identical and mirrored Collins's amended complaint filed in December of 17. So that's the problem. Collins amends the complaint, proceeds to add 2 new parties. At that point in time, after a year had already elapsed after Collins was appointed as receiver, did Mr. Bressi say, wait a second, I want to pursue these claims. And his claims were identical. So it was obvious from the order appointing Receiver Collins that he had no authority to do that. But in an abundance of caution and to be clear to the trial court, Receiver Collins didn't appear magically out of thin air. He appeared because of a written private settlement agreement. It's important that I read to the court the judgment entry appointing Receiver Collins. That's dated January 9, 2017. This judgment entry appointing Receiver Collins is identical in both the underlying case, Jared and Thompson with the victims, and then in this case before the court, the business litigation with his Summit Pain Specialist. First sentence, this matter came on to be considered upon the request of the parties through the respective counsel to appoint John Collins as receiver. So the party voluntarily requested it in both cases. The next paragraph, the request of the parties to appoint a receiver is part of their settlement agreement. So to say that the settlement agreement is not before this court, not a part, is just not true. The actual verbiage and the actual language obviously was a private agreement to which both parties were a part of and signed. But the court has been told, the court is aware that this receiver is to further a settlement. So to come and say that, well, that's private, we cannot talk about that, is only to serve the improper interests of Jim Bressie. The court, the order goes on to say that the receiver's part of the settlement agreement, which will resolve all the remaining claims in this proceeding and permit the plaintiffs to attempt to recover additional amounts pursuant to that settlement agreement. So it's just a myth to think that the settlement agreement wasn't before the court, and the court had engaged in ultra vires acts to bring him her knowledge from another case. No, the parties told her about it. The parties were informing her that this is the wishes of both parties. Interestingly enough, that was an order January 9th, 2017. That's a final appealable order. Jim Bressie never appealed that order. He was getting what he wanted. There was no reason to appeal that order. Everybody's happy, everybody's settled, everybody's moving on with their lives. It was a year later when Receiver Collins amends the complaint to add new claims. Suddenly, Jim Bressie gets buyer's remorse and says, I want part of these claims. Well, obviously, you can't. Not only was the receiver appointed to be the assignee of his claims, there was an order substituting Collins for Bressie. It couldn't be any clearer. There's just no standing whatsoever for Bressie to even attempt to assert identical claims to Collins. We are not here, Judge Sidosio, to say whether or not Jim Bressie tried to assert his own personal claims having nothing to do with SPS. He didn't try to do that. What he put before the court were identical claims that Collins asserted. So, essentially, there just is no standing. The reason why the trial court was emphatic about enforcing the settlement agreement in the first place is the only way that Jim Bressie's arguments can have any credence or any reliability is to void everything. Void the oral agreement, void the written agreement, which gave rise to the receiver, which gave rise to the substituting the parties. So Bressie's arguments, in essence, without actually stating it, are trying to undo all of that. The only way he could assert his own claims in this case is to ignore all of those voluntary written agreements. It defies logic, defies simple fairness to consider that that could be the case. There's simply no evidence that the agreement wasn't abided by both parties. As to the confidentiality or lack of confidentiality, Judge Carr, you're right to bring up the fact that Jim Bressie didn't literally say, here's the settlement agreement, but the subject matter was breached. Jim Bressie breached the agreement in the first place. That's why Collins brought it up. If it wasn't obvious enough from the face of the order appointing the receiver and order substituting parties that Bressie has no standing, the counsel for Collins decided, well, we probably should inform the court of the exact language of the settlement so that it is clear that it was intended all along that Jim Bressie signed anything having to do with sum of pain and a stock interest in the newly amended claims. With respect to the argument that there is some confidentiality of a receiver's property or a receiver's estate, that also is a myth. That is a myth. While the agreement says confidential master settlement agreement, the subject matter given to a receiver can really never be confidential. How else is the receiver supposed to report to the court, here's what I got, here's what I did with it, here's the money I received, here's the money I didn't receive. That subject matter, there's case law on that we cited that, has to be able to be discussed, okay? And again, it was never, the exact language of the agreement was never needed to be brought before the court until Jim Bresci, of course, first violated it.
Was a breach of contract ever asserted in the Thompson case? Thompson's?
It was not. It was not. Absolutely not. That, Jim Bresci kind of wants to have it both ways. He doesn't want to have to give back releases and have all 46 cases put back on the docket, but he doesn't, but he still wants to participate in other claims that he assigned. You really can't have it both ways. And there was
Neither party filed a breach in the other case.
neither party filed a breach in the other case. That is correct, yes. But again, I do think that's why the court felt it was important to enforce the agreements. If you have an agreement on day one, and then writing to memorialize that, then appointment of a receiver to accept the claims, and then the receiver pursuing those claims, and then suddenly at the very end, the party who assigned those claims says, I want in, I want back in. What? You can't. And because they're valid, because it's a valid agreement, sorry.
Ms. Geiger said that there was no motion to enforce the agreement filed in the other case either.
In this case or in the Thompson case, there was nothing filed in the Thompson case that I am aware of with respect to enforcing the agreement or a breach. Yes. So essentially, Bresci has no standing. On that final appealable order appointing Collins, that was the time to complain. Clearly that never, not only did he not object, he never appealed it. He didn't want to, he had no reason to, he was getting what he wanted, there was a mutual exchange. Again, a year later is when that was brought up, which is why this appeal, for so many reasons, has no merit, but certainly is untimely. Thank you.
All right, thank you, and Council, you'll have 4 minutes and 58 seconds for your rebuttal.
Thank you, Your Honor. Counsel talked about the myth. Here's the myth. The myth is when the trial court denied the motion for leave to file the amended complaint, the trial court cited to the settlement agreement. The settlement agreement was not before this court. If there had been two separate judges who had been randomly assigned to these different cases, this would never have happened because this judge, this randomly assigned judge, would never have known about what happened there and would never have been able to cite specifically to the agreement. Now, we have rules or we don't have rules.
Counsel?
I'm sorry.
No, that's fine. I guess I'm just not following that because I'm trying to figure out if somebody has released either their rights to file suit or whatever, and then they file suit, you're saying that you can never use the settlement agreement to prevent the suit from being filed?
No, I'm not. I'm saying there are ways to get the settlement in. And separately, when the trial court denied that motion, it denied it only in regard to this settlement agreement and the assignment clauses, which specifically quoted to. What they never did, it was a broad brush denial. What the court never did was, number one, look at the allegations and say, do these allegations fall within this assignment? Because it's not, I assigned my entire life away. The assignment's limited. And counsel even mentioned some of the limitation. The trial court didn't talk about that at all. The trial court, besides not talking about that, the trial court also didn't address the ability of the receiver to bring a cause of action or not bring a cause of action. What the trial court just did was say, look, okay, I know there's an assignment out there, you lose. Okay, that may be, but there are mechanisms for getting it in. Now, the trial court understood what happened afterwards because the trial court, a year later, said, oh, I better file this, and filed it under seal. All right? Now, I'm looking at, to me, that acknowledges two things. Number one, they knew they needed to have it there. And number two, they knew it was confidential. You talked about the confidential. It's called a confidential settlement. We talked about the confidentiality because the trial courts filed it under seal. And as this court knows, there are specific rules under Ohio, the governance of the court, as to what can be filed under seal and how.
So is it your contention that the claims that Bresci filed in his amended complaint are not the same ones that Collins filed?
No, they are close. My contention would be, I'm not so certain because there's never been an analysis by any court that those all were within the power of the receiver pursuant to the order appointing the receiver. Because as this court knows, receivers are only limited to what they're allowed to say. Now, so we filed something, but if absent a trial court going back and making a decision as to whether or not they fall within the assignments, I believe that's error, absolutely. And, other things I like to, some things make me a little bit crazy. August 27th, 2018, the trial court dismissed the case, period. Stuff happened after that. I can't figure out how a trial court can dismiss a case. And basically says, upon oral application of the plaintiff, receiver John C. Collins, the within captioned matter is hereby dismissed with prejudice. Well, to me, that sounds like, then the court went on and did other things that very same day, granted counsel's compensation, even though it was filed after the court dismissed it. Now, was that a mistake? I don't know. Was there ever a motion to vacate that? No, but the trial court just proceeded as if that didn't happen. We also had a motion to disqualify. It sat for 9 months. This is a motion to disqualify counsel, okay, based upon prior counsel for opposing party, based upon the fact that they represented Mrs. Bressie. It sat for 9 months and it was never ruled upon, period. Your Honor, what I submit to the court is that I understand this assignment issue, but the question is, do we start at the end and work our way forward, or do we start at what the judge, with the motion, the opposition, and the court's ruling, and look at what was before the trial court? If we're just going to be allowed to bring things in from other cases without following rules, just tell me, I'm a trial lawyer. I'd like to know how to deal with that down in Summit County. I'll just bring stuff in, and then I could cite to the court. All right, but no, that's not. We're a rule of law, and these are procedural due process matters, and Mr. Bressie, over the course of time and via the cumulative evidence rule, okay, if you add up all of the different small pieces, they add up to accumulate to a deprivation of due process, which Mr. Bressie is guaranteed under the Constitution. Your Honor, thank you very much, and I'd ask the matter be remanded for further proceedings.
Well, thank you both for being present this morning and for your arguments. The court will take the matter under advisement, issue a decision in due course. The clerk of courts will mail all counsel a copy of the court's decision on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. Again, we want to thank you for your appearance today and your